Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Hello, and welcome to another episode of Case Autopsy. I'm your host, Mike Campbell. I'm excited for today's guest, Mark Prince. Mark is an outstanding trial lawyer from Southern Illinois, handles cases throughout all of Illinois, and was actually elected as president of the Illinois Trial Lawyers Association by his peers. So he's a guy, he's got a lot of credibility, not just among his peers, but also among everyone who practices throughout the United States and knows Mark. I'm excited about today's episode specifically because Mark is just so open and willing to talk about his affinity for the profession. I know that he thinks it's a sacred obligation and he really cares about his clients. So hopefully we can get to talking about that as well as a recent case that he had. So buckle up and let's get to it.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Mark, how's it going, brother?
Good. How are you today?
Good, man. Hey, tell the audience a little bit about yourself and your practice.
Well, my name is Mark Prince. I run a solo firm in Marion, Illinois. All we do is personal injury. We try cases here at the firm. Seems like I've been trying a lot of zero offer cases lately, but you know, once I take a case, we're committed to it and we try it to the end. So
and that makes it a little bit easy. It's as frustrating as it is when you've got a zero offer. It takes a little pressure off in communicating the decision with the client.
Well, it takes a lot of pressure off of me as the trial attorney going in with a zero offer case. But every time I go to trial on a zero offer case, I remind the defense lawyer of the Warren Zevon song, Lawyers, Guns, and Money. One of my favorite verses is, and I tell him this could be your walk-up song at the trial is, send lawyers, guns, and money. The shit has hit the fan. Sometimes they appreciate it. This trial we're going to talk about, I think he realized that he needed to listen to my buddy Warren Zevon a little bit closer to his.
Right. That's funny, man. I always think about that scene in Braveheart where they're all lined up to go fight, and then they start doing negotiations. The Scottish lords are doing negotiations, and then William Wallace, Mel Gibson goes, we're gonna go peck a fight. And the one guy looks at him, he goes, well, we didn't get all dressed up for nothing. And I mean, that is literally that is my philosophy whenever it's like, oh, we're going to try this case. Well, we didn't get all dressed up for nothing,
That's right.
And then when, cause I mean, shoot, man, like I'm guessing you had a few losses in your life, in trials. I will tell co-counsel, like, we're not settle lawyers. We do some settling, but we're trial lawyers, and this is part of it.
That's right. We try a lot of cases that way, and young associates that I've come in, I'll assign them cases, and they'll come to me and they'll say, "This isn't very good," and I go, "It's as good as you make it. Try the case."
That's exactly
strange things happens in court, I'm sure most everybody listening here has won cases they thought they were going to lose, and they've lost cases that they thought there was a good chance they were going to win. But that's why we try them.
You have to get your sea legs under you a little bit to know that it's okay to get in the ship, right?
Yeah, absolutely. And I've been doing this now for a lot of years. When I first started trying cases, I was afraid of a loss, because I was afraid that other lawyers would look down on me and I was kind of embarrassed. But it's like the man in the arena. You've got to get in, you do it anyway. And every trial lawyer from whom you would want any respect has been in that situation where they've lost a case, and they know what it's like to try a tough case and to get a zero verdict. But I think that's one of the big things I tell the younger lawyers: try your case.
Yeah.
Don't buy into the propaganda of the defense lawyer. Try the case.
See what happens.
See what happens.
And it takes it's like chicken and egg, right? Because you have to, face the trial by fire a little bit before you can face the trial by fire.
Well, and this is a reputation driven business. And if you have a reputation that you're not going to try a lawsuit, you're not going to get the best settlement offers on the cases that need to be settled.
That's right. Because some of them do. Some of them deserve to get, resolved. And I know that insurance companies carry files around of, electronically of all the lawyers they negotiate with. And they say this guy took or gal took 33% less than what was, due on the file. You know that as well as I do.
And you know what, as strange as this sounds, we're talking about losses instead of victories. But that's a reality of our profession. Some of the best sources of business and new cases for me have come from clients whose cases we have tried and got a zero verdict because they know how hard we fought. We were elbow to elbow, working, picking a jury, preparing examinations, going over doctor's testimony and voir dire. And so they know how hard we work. They know how hard it is.
Yeah, that's right. I mean, the last one I got blanked on, I remember my client afterwards giving me a big hug and saying, hey, thank you for everything that you did for us. Yeah. And it wasn't what I expected. The next one that we didn't get what I thought we should, the lady came in and said I wouldn't change a thing. And I just was, rewarding to hear that. I wish we would have obtained better results. Yeah. But you're right. You got to go to the mat. And part of going to the mat is you're going to take some losses.
Yeah. But I also think, and this has been part of kind of my marketing plan, if you want to call it that, is I will talk to just about anybody that calls the office. I will, very few times do I say, no, I don't even want to talk to this person. I usually bring them into the office, and now we're back doing everything in person again, which is great. Bring them into the office, and even if going into the meeting, I know I'm not going to take the case, I let them talk to a lawyer. Because contrary to popular belief, most people don't know a lawyer. Most people think that we're anything but a real human being. And so they leave the office, even when I've got to tell them the news that I don't think you have a case and here's why. They at least have had a chance to talk to a lawyer. I think they sleep better at night. The stress is kind of reduced for them. And I am all of a sudden their lawyer. So when mom or dad or brother or cousin or friend get in an accident, call my lawyer. Because everybody likes to say, call my lawyer.
That's right. Exactly. Call like my lawyer came by today. Yeah, someone pointed out to me once. We were working on a case. We were getting ready for trial and we were going to meet with our client. And the co-counsel I had was like, that guy tells people, hey, I met with my lawyers today. And it never even occurred to me how meaningful that is for someone to say, I met with a lawyer. I met with my lawyers today.
Yeah, exactly. Yeah. It gives me peace of mind more often than not. And, we're I still think of us as we're a service profession. We're here to help people. We got to run a business also, but that's a service we can give that takes 15 minutes of our time to talk to them. It just makes them feel better about their situation.
And has your experience been when you decline a case that and you're honest with people that they push back, or has it been that they are just grateful for having talked to someone who told them the truth, or
Well,
both?
I think it's both. I think it's a mixed bag. Um, I always encourage, if I decline a case for a specific reason or just decline one in general, I always tell them, talk to another lawyer. Different lawyer may have a different opinion. Just don't take my word for it.
Sure.
And they will do that sometimes, or I'll get a call occasionally and say, hey, can you explain this? So I'll spend some more time to talk to them. It just further bonds us to one another, I think.
Yeah, yeah. You had a trial recently, and let's talk about that case. Are you cool with that?
Sure, that's great. That's
All
great.
right. Give us a little bit of factual background on the case.
Okay. Well, let me just say, this is a case I took after another lawyer had it, fired my client, my future client, and did so in such a disgusting way that I felt sorry for this guy. And I thought, well, I can help you here. But anyway, and so here's the factual background.
Let me ask you this, Mark, real quick.
Yes.
Without divulging confidences, tell me about like okay, so what are you feeling whenever you find out that this guy was basically canned by another lawyer? Was it just the way in which, well, I'm kind of curious about why you felt so righteous about it. And I guess maybe that could also inform us a little bit about the background for why you felt that way.
Well, when I read the emails and the letters from the lawyer that discharged my guy, I was embarrassed to be a lawyer, which hasn't happened very often in my career, but it was just so mean-spirited. And really what triggered it is my guy was just calling to say, hey, what's going on with my case? And the lawyer just went off on him.
We're not going to answer we're not going to answer your one question. What's going on?
We're not going to tell you what's going on. Just listen to us. We're the lawyers, which is probably not a great way of practicing law.
Right.
But my wife will tell you sometimes I don't make the right decisions. If I was looking at this in a sterile environment, I probably would not have taken the case. But given the circumstances and the emotions involved, I just kind of felt for the guy. And there was enough meat on the bones where I thought I could do something for him.
So you're looking at this basically redemption of the profession a little bit, but also, and you kind of know what I mean. It's like,
What you mean?
Hey, we've got a sacred duty here, in my mind. I'm going to do what I can for you. And then there's some facts that you can work with.
Well, and redemption, no, I'm not that noble, but I do like.
You have horses, so you can be a knight, right?
Yeah, exactly. But I do like people to think highly of our profession.
Yeah.
And the more I got into it, the more I talked to the guy, the more I liked the case. But what brought him to me was when he came in, he was 70 years old. He was a type 2 diabetic. He was, shall we say, not very well controlled.
Mm-hmm.
During this particular hospital admission, he checked in, and I think his sugar level was like at 500.
Oh, wow.
It was amazingly high.
Yeah.
And he had developed a diabetic ulcer on the ball of his right foot. It was pretty bad. So he goes to the hospital, at a local hospital. He checks in. The ER doctor looks at him and says, "Oh, problem. We need to have a surgical consult. So this is like day one at 6:30 in the evening. Okay. Calls for the surgical consult. The surgeon doesn't come in until day two at 4:30 p.m., almost 22 hours later. Looks at this guy and he says, "Oh yeah, we need to debride this. This is a bad situation. We need to debride it." But he doesn't debride it until 14 hours later. Okay. So now from admission to the debridement, 36 hours, this guy's laying in the hospital waiting for some sort of definitive treatment.
Okay.
And the surgeon, this is how bad this situation was. The surgeon had treated my guy for the same diabetic ulcer a month before at the same hospital.
Okay.
And had debrided it. So he had some prior knowledge. But so he does a debridement. Of course, it was insufficient. Day 4 in the hospital, my guy develops a nasty condition called necrotizing fasciitis, which is basically a flesh-eating bacteria. Starts moving up his leg. Ends up in St. Louis having an above-knee amputation on day 5.
Oh, wow.
Bad situation.
Develops really rapidly.
That's a bad thing about necrotizing fasciitis is it's a fast developing, it's somewhat rare, fast developing. The interesting thing is one of the battlegrounds we had was causation because his foot was in bad shape. I got the defendant surgeon in his deposition to testify that, when my guy checked into the hospital and he first saw him, the foot was viable, it was savable. He decided to do the debridement because it was savable and viable. And had he thought it was not savable, he would have just went straight and amputated the foot. The problem I had with my own expert on causation said my guy was losing the foot anyway. That's how far gone he was when he came into the hospital.
So that's interesting.
He was going to lose it anyway. So it put the defense in a bit of a predicament. And then their expert then comes in and says, of course, he's going to lose a leg no matter what, which completely contradicted what the defendant surgeon said. It was savable.
So what are they going to do? They're going to try to basically contradict their own person by saying that the foot was savable in an attempt to show that your expert doesn't know what he's talking about, that the foot wasn't savable. That's a bind.
It was quite, as they say, a conundrum.
Yeah.
But it's a med mal defense. So, whatever they'll say, whatever they need to say.
Yeah. Let's throw it against the wall and see if it sticks. Yeah. Yeah. So, how many experts did you have, Mark?
I had 2 experts. I had a vascular surgeon and a general surgeon. And they took care of me on standard of care and causation.
Both of them. So,
yeah.
So were those subsequent treaters or were those retained?
Those were retained.
Okay.
The subsequent treater was not going to, the best I could do with a subsequent treater is say he has no opinion.
Yeah, sure. He did this thing.
Opinion, it was not going to be favorable to me on either causation or on standard of care.
Sometimes a neutral's a win, right?
Yeah. Well, big win in this case.
Big win, yeah. Especially if it's a med mal. That's right. Yeah. What is your guys' life like before and I guess compare that to the after? Because you've got the liability, it seems like, worked out, but now you got to talk about damages.
Yeah. Well, I mean, we had liability covered. It was not in the bag by any stretch of the imagination.
Exactly. You were not in a med mal case at all,
yeah.
right? Yeah.
Because as much as I wanted to believe, I'm not sure I believed everything
Right.
on the liability, standard of care issues. But, you know, he was 70 years old. He was as active as he could be. But when he lost his leg, we went to his house and we shot some day in the life videos, just showing how he had to climb upstairs because he couldn't wear his prosthesis. It bothered him, and he just didn't like to put it on. But so just crawling up his butt one step at a time.
So like sliding
Yeah.
up, sliding up.
Yeah, and then sliding down and just, you know,
Wow.
transferring from his chair to the van and to all the things that had to go to just to you know, eat dinner.
Was this a big guy, small guy?
He was, by the time he got to me, you know, he was much smaller than he was when this all happened.
Really? Was it
weight wise and everything, and he was under control,
right?
Wise when he got to me. But one of the most poignant moments was, and we didn't get this far into the case. We settled it after opening statements for a fair sum, I think. But his wife, 68 years old, she builds a wooden ramp from their front sidewalk to their front door so he could get in and out of his house, because they had a deck and you had to climb 2 or 3 stairs to get into the house. So, you know, the damages in a case like that, they're always compelling.
Right.
But it's kind of getting over some of the liability hurdles. That's what's hard.
Yeah. And they are compelling, but you also got to deal with the fact that they just talk about, well, this guy's quality of life for this reason. This is where I would be real uneasy on the other side. This guy had a bad life beforehand for X, Y, and Z, right?
Well, one of the defense lawyers, we also sued the suit was filed by the time I got into the case, and the statute had long gone. Was one of the lawyers, when we were talking about during expert discovery, talking about the sufficiency of the debridement and that it wasn't insufficient and it needed to be much more aggressive. This guy started talking about, to my expert and then to his expert, that the degree of debridement that we said needed to be done would have deformed his leg.
Oh.
He would have had pockets of flesh missing. Like, that would be worse than losing your leg.
Again, one of those throw it against the wall, right?
Well, we never got to present any of that or voir dire on it or anything, because the hospital offered us enough money to where we couldn't say no, and they weren't really my real target anyway.
Sure.
It was the surgeon. So, but we had a couple interesting things happen during voir dire, which is why I always advocate as hard as I can. Let the lawyers ask the questions.
Right.
And our trial judge was just great. He gave us, in Illinois, we get a lot of leeway on voir dire. And likewise, I got a lot here. But what was interesting, I've tried lots of cases, but this is one of the first times that even before I could start introducing my themes, just in general voir dire, and you always want to get people talking, and I, these jurors got to talking with us and back and forth to one another and about stuff. And of all things, as crazy as this sounds, but remember, we live in a very rural area. We were, one of the jurors, I let it out that my wife raises chickens and we got chicken coops, and one of the jurors just volunteered, so do I. We raise chickens. And I've got a skunk breaking into our chicken coop and killing my chickens and eating my eggs. And I go, so do I.
Same skunk.
Yeah, it's talk about hunting skunks and things like that.
Yeah.
But then she says, and I know where the weakness in my coop is, where the skunk is getting in, and I just haven't fixed it. And one of my themes is time. Time is of the essence. Don't put off until tomorrow what you could do today.
Yeah.
Follow with a delay, this guy laying in the hospital. And the lady juror just says, well, like we were taught as kids, time's of the essence. Procrastination never turns out well. And I thought, well, I had thought about the procrastination angle, but that's a new theme now in my case.
Yeah.
And so, we're not even talking about anything fact specific, but she's reiterating, or she's iterating my theme. And then, we're talking, a couple other people start talking about how in their job, time is of the essence and things of that nature. So they don't know anything at all about my facts at this point. But then fast forward to opening statements, and, it's this courtroom had really good tech. And they had TVs mounted from the ceiling that would lower an angle so the jurors could easier see them. So I could, thankfully I was short enough, I could stand right under that TV screen, and I had just a big blue screen with time on it. And I start talking about time and the facts of the case. And as I'd switch to a timeline, I'd say time is of the essence. Time is of the essence. And the third time I said that, I could see jurors mouthing time is of the essence. So they were, I think part of that was they were pretty accepting of that theory, of that theme, just based upon voir dire. So,
Yeah.
surprisingly, that when that happened, two of those jurors remained on my jury. They weren't taken off by the defense. So, but that was just, it was one of those things that we're always taught, ask a question, but listen to the response. Don't be writing, listen to what they're telling you. And by listening, I'm thinking, oh, not too bad. Well, the defense lawyer thankfully was listening too, because I think he started getting a little bit worried. The defendant doctor, I could catch him out of the corner of my eye. He was not real happy, I think.
He wasn't mouthing time time is of the essence.
No.
Yeah.
He'd been living that. I think he knew that
Right.
that was going to happen to him. But we also, diabetes was one of the issues, and I'm talking a lot and I'm probably rambling on. Sorry about that. But I just found that this was interesting. We had diabetes, of course, my guy had, so that was a central issue on causation and standard of care, especially him being out of control or uncontrolled. But there were 3 older people, very heavy, that started talking about how they had type 2 diabetes. And they swore up and down to us that they were controlled. I knew enough about it by looking at them and talking to them. I suspected that they were embarrassed to say that they were not controlled, but I did not think they were controlled.
Sure.
So, we decided to leave them on because I thought they could relate to my guy.
Yeah.
And one of them, I really wasn't going to go here during the trial, during the presentation of evidence. She says, well, diabetes is an epidemic in this country. And I thought, I really love you. Do you have anything else you want to say? And so they were talking, and then, it led to diabetes should be treated. Diabetes should not be a death sentence. And one guy was not with me on it. He goes, well, you lose limbs when you have diabetes. That's just the fact of life. couple other people, it's another one of those examples of getting jurors cross-talking, disagreeing with each other and things like that. So it really worked out well for us.
Did
during
you
the selection?
did you have your client in the courtroom during jury selection?
I did.
Okay. Some people do not. I just was wondering if
I wasn't going to have him there for every day of the testimony.
okay.
I like to have my clients there for voir dire, especially where I'm at. I'm in a small community, and we can look at a list. We can get the veneer and look at it. And you know as well as I do, there are 1,000 people in your life that you know by sight, but
Yep.
for the love of God, you can't think of what their name is.
Yep.
So I like to have my clients there so they can see the people that I'm questioning, because they may know them.
Gotcha.
They may not know them by name, but they know, hey, I used to see this guy in the restaurant and he was really cool, or he was rude or obnoxious,
Makes
little
sense.
things like that. So
Makes sense.
I usually have my clients there, and I had my client in this case present too.
Yeah, because the reason why I was asking is I could see a juror not being with you. You had talked about the diabetes, the juror telling you diabetes is an epidemic. I could see that going the other way, where they're like, look, this is not anyone's fault but the client's. You're the plaintiff, and I could see them plaintiff blaming, right? It's protective mechanism we all have, that this couldn't happen to me because I'm going to make better decisions. Well, the reason why this guy's in this position is because he made worse decisions. Does that make sense?
It does make sense, and that is a real risk in a case like this.
Sure.
That's why, if we would have went to verdict, I may have made the wrong decision by leaving them on. But my gut instinct was leave them on, because I just felt that they weren't being completely honest about how controlled they were.
Oh, I got you on that.
So that's why I thought, I know that bias is there. It won't happen to me. I'll make a better decision. But I kind of got the feeling that they'd had issues before.
Mm-hmm.
And I wasn't going to ask them about that, because I'm not going to get that private or embarrass them that much. But it was a gut feeling, that you develop that sometimes after 30 years of trying lawsuits.
That's right. And if you have like one or two goals in jury selection, or one or two goals for this jury selection, say, okay, if I can do this one thing, what's that one thing or one question, one objective you wanted to do?
Well, the big thing that I want to do in every voir dire is I want people to talk to me. I want to have a free-flowing discussion. I tell them it's the only chance you're going to get to ask me questions, and this is a safe harbor. No right or wrong answers. Tell me what you think. I need to know what you think. And sometimes jurors are better about expressing their opinions than others. But in this one, I think it started off slow, but they warmed up. And what I really try to do is get them to forget I'm there and just talk amongst themselves.
Sure.
That's what I think that is the most successful voir dire you can have, is when your potential jurors are discussing issues that you may suggest and moderate and lead them through the discussion, but talking amongst themselves. I think you really find out what's on their mind, because you've done this enough. Everybody listening to this has done this enough. Everybody says, yeah, I can be fair.
Oh, yeah.
Sure, I want to be fair. You bet. No, I can listen to what you said. Oh, no, the defendant doesn't have a lead on you out of the gate. No, absolutely not.
Fair and impartial.
Show me the evidence. If I'll award whatever it warrants. But we know that's not reality. And I think whenever we get them talking like that, we get a peek behind the covers about what they're really thinking. And then you can follow up, on those specific opinions without making them feel bad about having the opinion they have. So that, I think that's the biggest goal I have. I don't really go in with a goal thinking that I'm going to, I probably shouldn't use this word, indoctrinate them on the facts of my case. Because we get a lot of leeway here in Illinois, but when we start trying to indoctrinate, that's when we get shut down pretty quickly.
And that could backfire very quickly on you as well, right?
It certainly could.
Because if they're not with you, you don't want them to be against you right out of the
Right,
gate.
exactly.
Yeah.
So you can do that with. It turned out that this was one that just a lot of discussion on diabetes, but we do it like on what their thoughts on the jury system. And where I live, this is a big Second Amendment area. Everybody has a gun.
Mm-hmm.
Everybody has concealed carry.
Mm-hmm.
Anybody, they're constantly afraid that the politician of the day is going to come after their guns. Never happens in Illinois, but that's what they're afraid of. So, what we do is we at least what I do, most people don't understand the Seventh Amendment right to a jury trial. They just don't. They stop at the First Amendment, Second Amendment, and that's it. So I asked him, do you realize that what we're here today is guaranteed to us by the Seventh Amendment, just like the Second Amendment? I tie the Seventh Amendment to the Second Amendment, and all of a sudden they get it.
Sure. Yeah. And you feel comfortable talking about the Constitution? I mean, is that a theme that you hit on in your opening statement as well?
I do, and I'm not sure it's necessary.
Right.
But I think it's, and I have this conversation with myself every time. I think it's one of those things I do because it makes me feel better, because it makes me feel like this is what lawyers are supposed to do. Because even though I've shrugged off a lot of lessons I've learned early in my career about how to pick a jury, a lot of defense lawyers have it, but I still can't get out of that mode of talking about, our jury system is the greatest. It's your only one of two times you're involved in government, vote and serving on a jury, and how we brought that over from England. And I just can't help saying that. Now, I used to have a longer segment, but I guess I've compromised with myself, and I cut that down to about a 30-second that I bury, after my opening tagline and thanking the jurors and
Yeah,
and then going back into the meat of the case.
yeah. No, I mean, I've given that a go. I think there's something that, like you said, just as being a lawyer and understanding the background of, I want to talk about this, and also, the way in which I couched it was, you're here to resolve a dispute between the parties, and the Constitution gives both parties that right. And what an awesome responsibility that is. I wonder sometimes if that falls on deaf ears, but I feel like I would hope that if we mean it, they can feel it.
Well, I do think they appreciate hearing it. I think they listen to it. I think one of the things that we lawyers sometimes overlook is how seriously jurors take their job. This is a different case I tried. One of the first cases that I tried since we were back in the courtroom, but it happened over last Thanksgiving, and it was like a 3-week-long medical malpractice case. And, we had all the COVID restrictions in place. Lawyers still had to wear masks. Jurors had to wear masks. Witnesses did. The judge did. And our judge gave a questionnaire about COVID and, asked various attitudes. Is it a hoax? Is it fair? Is it real? Is it imagined?
Sure.
Political which gave us a lot of valuable information that we didn't have to talk about in open court during voir dire. But after the first week, one of the jurors, and we knew by this questionnaire he was not vaccinated, told the judge the night before he got exposed to COVID from his wife and his daughter. So we had plenty of alternates, and our protocol was, well, we'll just remove him. Okay. Come to find out, well, and then we bring the jurors in because we felt like we needed to tell the other jurors that they had been exposed potentially. And we decided to do it on an individual basis instead of as a group.
Yeah.
Because we were afraid if we got one person to say, no, I don't want to go on, they would all say that.
Yep.
Each and every one and all the alternates, we said, now this has happened. How do you feel? Do you want to go on? Do you want to not serve? And every single one, every single remaining juror and every alternate said, oh no, let's go on. We're comfortable with the court's protocols and safety. This is too important of a case.
It's incredible.
We want to see it to the end.
That's amazing.
And that, we get crusty sometimes, but that just renewed, as if it didn't really need it, but it renewed my faith in the jury system. These people take their job seriously.
Well, you use the phrase "to serve." I feel like that's an overlooked phrase. When you said it, it came across powerfully to me. And I don't know if it's just sometimes we overlook simple things of emphasizing that people do want to serve.
Yeah.
Right. They want to roll in making society work.
Yeah. Everybody wants to do something important.
Right. Be a part of something important.
Yeah, be a part of something bigger than themselves and part of history. So
yeah. This case got resolved after opening, so obviously something must have happened. Or, I mean, tell us about what the opening was like and what themes you hit on. And you already talked about time is of the essence, but how long was it? What did you talk about? And what ultimately led to the discussion of trying to get the case resolved?
I'm a believer in brevity, despite maybe my ongoing conversation here.
No, this is fun, but we get to talk. Like yeah. Someone can turn us off, Mark. Exactly. A juror can't get.
Who would want to turn us off?
Right, exactly. Come on, man. Yeah.
My opening statement was about 25 minutes long.
Good for you.
And I most of the time stood under a TV screen, a big screen. My PowerPoint consisted of about 4 slides. It was all on a blue background, truth. And it said time. And then the person running my tech, every time, she knew when I was coming up. Every time I was about to say time is of the essence, that slide would come up. Or don't put off until tomorrow what you can do today, that slide would come up.
Were they the phrases time in like white against the blue background?
White words against a blue background.
Don't put off what you can today, or don't put off to tomorrow what you can do today.
Right.
Time.
No photos, no graphics or anything like that. And then, whenever I talk about the facts of the case, we'd switch to different, timelines that we'd show the defendants minute by minute actions. So we use that. But I really kept it short and sweet, no extraneous. I knew my defense lawyer, and I knew he was going to throw everything in the world against the wall. He gave about a 45-minute thing. And it was effective, I think. It was more effective on my client, I think, than it was on the jury. We went into this case, it was essentially a zero offer case. But after openings, there was a discussion, and we resolved the case for a fair sum of money. And I think, as a lawyer, we could tell our clients, this is the bad thing about your case, ABC. Oh yeah, but I don't believe that. But it sometimes carries a little different weight when they hear it directly in the courtroom
Right.
or an opening statement.
Right.
All of a sudden,
Oh,
hey,
this is
that guy
real.
that defense lawyer I thought was a jerk. Well, he may not be so unreasonable after all.
Yeah.
And I think that the defendant doctor thought the same thing. As the judge told me afterwards, he goes, "Well, I think you scared the defense with your opening, but I think the defense scared you with their opening." Go, well, that's pretty doggone accurate, Judge. So
That's the important part of the process, right?
yeah,
It's like, hey, we're both,
yeah,
playing a little chicken here. I tell people I don't like to gamble because I already do enough of it in my practice. We're little riverboat gamblers to some.
well, and and I was ready, of course, to try everything. We figured it was going to take about a week to try. So both lawyers were committed to doing that, and had all our witnesses lined up, our experts coming in on their schedule and things of that nature. But the bottom line is that's what my client wanted to do. So
Sure.
we're here to serve them. He was happy with his decision. He got some closure to it.
Great.
No appeals, no verdicts. So it's bittersweet because when you start, you want to see it to the end. I think this is maybe only the second time that I've started a trial and settled it midway.
Yeah.
I don't recommend it, but if that's what your client wants, that's what you need to do.
Well, it's not just that, but it sounds like, I know that you weren't you weren't trying to ascribe nobility to your actions, but if it sounds like your client's, view of the profession was redeemed to some extent, was satisfied with the outcome.
He's happy with the result. This is going to sound a little corny. I'm sorry about that, but I think we consider one another to be a friend.
That's nice.
Not just a lawyer client, but friends. So I mean that's important too.
Yeah.
So I think this is a weird type of law we practice because
it is, man.
there's
It is
so many different things that happen that can go either way. Sometimes you might try a case and the client thinks you're horrible. Other times you settle a case mid-trial and they're your buddies. So
yeah, I mean, I have a lawyer friend who texted me during the trial and he was like, I'm sitting here, the jury's out on a break, and I'm thinking to myself, what have I gotten myself into with this profession? Yeah. And it's like, yeah, man, because I remember just standing in front of the jury trying to talk to them, and in my mind observing what I was doing, thinking, what are you doing? Like, what kind of thing did you get yourself involved with here, fella? And it is a very interesting profession. I think it's true that we get to find out who we are when we're in front of them and when we're with our clients.
That's true. I do a lot of head scratching, and usually as I'm preparing for trial, it's like, what were you thinking?
Yeah, right. You're like, oh my God, this is not good.
Yeah. My office staff, they need to learn a lesson that they cannot let me talk to anybody about a new case.
Yeah.
After I come off a good settlement or a good verdict, because I start feeling cocky and think I could do the same thing on every case. So they just need to protect me from myself.
Yeah, I was walking into a trial with Tad, Tad really well. And I remember seeing these guys working on this building, and they were like doing construction. No, it was actually they were laying asphalt. And I know that's a terrible job in the middle of the summer, and because I've been involved with a lot of different jobs like that. But I remember thinking, man, just to be out there laying asphalt, not having to deal with what we're getting ready to deal with. Maybe I should have done that. But then you go in and you swing away and you do what you did for this guy, and you're like, wow, win or lose, this is pretty cool what we do.
Yeah,
pretty cool.
It is. I'm not qualified to do anything else, of course, but I can't imagine doing anything other than this type of law. I just cannot imagine that.
Yeah. Well, I think that's a good stopping point, Mark. I don't know how we could end it any better. I'm going to put some information in the show notes about how people can reach out to you. You handle cases throughout all of Southern Illinois, throughout all of Illinois, frankly, right?
Correctly. Yep.
If you're listening to this and you're looking for someone in that region, this is Mark's your guy. So
yeah, or if you just want to spend a few minutes and talk about nothing, hey,
that he's a great guy to do that as well. Yeah, that's right. Mark, I appreciate coming on today.
Thanks for having me, Mike.
All
I
right.
appreciate it, brother.
You're listening to the Case Autopsy, the Verdict and Settlement Podcast. This is Mike Campbell.
Hey, thanks so much for joining us for another episode of Case Autopsy. I hope you got a lot out of this episode. I know that I did. If you ever want to get on the pod and talk about a settlement or verdict that you have, or a loss that you've taken and you're willing to discuss that, or you just want to talk about general aspects of the law, please do. As you can see, these are wide-ranging interviews, and we'd love to have you. We're also open for interviews for Lawyer Minds in written format. Those interviews will give you backlinks and give you good social media push. So feel free to fill out the interview request form and reach out to us if you want to be a guest on the podcast. Thanks so much.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.